Hello, everyone. My name is Czak, an attorney, a labor and employment attorney with Husch Blackwell's Healthcare, Life Sciences, and Education Group. In addition to labor and employment, general counseling, I typically focus on traditional labor law, collective bargaining, labor arbitration, union contract administration, and NLRB proceedings and the like. Thank you for joining our program today. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit those directly via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or if we run out of time, it will be answered later via email. Also, a PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours as well as HRCI and SHRM credit. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow along with a recording of the webcast for watching and sharing. Toward the end of the program, please be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And that is all for the housekeeping items, and let's get started. So presenting with me today is Rufino Gaytán, an attorney in Husch Blackwell's Healthcare, Life Sciences, and Education Group as well. He has significant experience representing clients in labor matters, collective bargaining, arbitrations, ULPs, and all matters before the NLRB. He also has extensive experience before OSHA, as well as litigating claims in state and federal courts and the EEOC. So thank you all for being here. We're here to discuss post-election analysis and the impact on labor and employment law. The election has come and gone. It's been a contentious campaign season. We know the results. President-elect Donald Trump will be returning to office come January 2025. And although we don't have a crystal ball, we do have a prior Trump administration to look back on to try to predict or see into the future as to how his administration is going to impact labor and employment law. What we think a general trend or theme of the Trump administration could be is a pushback against the expansion of agency power. I'm sure you all have seen in the news, Vivek Ramaswamy and Elon Musk were appointed to this so-called DOGE, Department of Governmental Efficiency. Not that that is a real federal agency, but it kind of sets the tone and tenor of what a Trump administration may pursue. The thought that the federal government is bloated, the wanting to cut certain federal agencies, reductions in force of federal employees. That's not to say that that is definitely going to occur, but it just demonstrates the potential tenor of a Trump administration down the road. So what we're going to be speaking about first is the National Labor Relations Board. Like I said, both Rufino and I are traditional labor attorneys, so this is our bread and butter. And traditional labor law and the board will probably face the biggest change in this administration out of the areas of labor and employment law. Just a reminder, the NLRB and the NLRA, it applies to private employers and not necessarily just employers with a unionized workforce, although, unions are a huge component of it. The protections under the NLRA, the National Labor Relations Act, apply to all employees, not just employees that are members of a union. So just to start, about what is the National Labor Relations Board. It's a federal government agency, and it's charged with implementing labor policy in the private sector and administering the National Labor Relations Act. And it's comprised of the general counsel, and that is the chief prosecutor and legal advisor for the board. And basically the GC oversees the enforcement of the act, prosecutes these unfair labor practice charges, and the GC is appointed by the president with the consent of the Senate, and it's a 4-year term. Then you have the board composed of 5 members. They're also appointed by the president with the consent of the Senate, and the board determines the labor policy through the decisional precedent as well as rulemaking. Currently, the general counsel is Jennifer Abruzzo. She was appointed on July 22nd, 2021 for a 4-year term. And then the board composition is the chair, Lauren McFerrin. It's a Democratic seat. Then we have David Prouty, Gwen Wilcox, again, all Democrats as represented in the blue. Marvin Kaplan is currently our only Republican board member. And then there's also one vacant seat. As I'm sure most of you are familiar with, Jennifer Abruzzo has taken a rather aggressive prosecutorial stance in implementing a very pro-labor agenda. We think she's probably one of the most aggressive GCs in recent times. And her tenure has really been emphasized with an increased protection of workers' rights and expanding the board's role in safeguarding labor practices. She's taken an active role. She's issued substantial number of general counsel memoranda, I think upwards of 25 during her tenure so far. And just to note, those GC memoranda, they're not legally binding necessarily, but they do provide direction for the board's regional offices and signal how the board may interpret and enforce policies under current leadership. They offer just guidance and kind of a roadmap for us as practitioners as to how the general counsel is going to interpret labor law, prioritize cases, and enforce policies. So what's next in terms of the general counsel? Rufino is going to speak shortly about the board, but first looking at the GC. Historically, the GC has been permitted to serve out their full term, regardless of the administration change. That did change, though, when President Biden entered office 4 years ago. In an unprecedented move, Biden actually dismissed outright the Trump-appointed GC, Peter Robb, because he refused to resign. And Biden did that actually on Inauguration Day, which was about 9 months before Robb's term was even set to expire. So that had never happened before. And as a result, we do expect Trump to return that favor in kind. And on Inauguration Day or shortly thereafter, we do expect Abruzzo to be dismissed if she does not resign on her own. So what is the immediate impact of that? Basically, what we could expect is with a new GC, there is going to be a change in direction of the labor policy and that GC's agenda. We would expect that a new general counsel would likely rescind many of those aggressive pro-labor GC memos that Abruzzo has issued over the past 4 years. As basically the Biden appointed acting GC did that within 2 weeks after Biden took office. So a bunch of the pro-employer GC memos that the prior administration issued, that new GC, rescinded them all. So we do expect that to occur basically on day one when Trump appoints a new GC. And we just wanted to show you a few of these GC memos that have been issued that were pretty historic and that we do expect to be on the chopping block relatively soon after a new general counsel takes office. So the first is GC Memo 24-04, and that basically expanded remedies for employees. And it was a really novel look at these full make-whole remedies. And the GC took the approach that if an employer commits an unfair labor practice, that there's a broad range of financial hardships and losses that employees may face. And as a result, it's not just back pay that they're owed. An employer can be on the hook for accrued interest, late fees on rent, utilities, car payments, credit card payments. If utilities are disconnected, the cost of that and the reconnection fees, daycare costs. If they withdraw from their 401k early and there's penalties for that, job search costs. So really kind of blew the door open in terms of what an employee could seek for an unfair labor practice. Again, we expect this to be rescinded, shortly thereafter Trump takes office. Another GC memo, this is the most recent. It challenged the legality of a stay or pay provision. And basically, if you're not familiar, a stay or pay clause requires employers to, repay bonuses, training costs, education costs, if an employee leaves employment within a certain period of time set forth in an employment agreement. And the GC takes the position that These types of stay or pay provisions, they limit employee mobility, they discourage employees from exercising Section 7 rights for fear of termination or being let go. And they're really presumed to be unlawful unless they're narrowly tailored. And the memo sets forth a bunch of steps that employers have to take to make sure that their agreements are in compliance with that. The deadline to do so is December 6th to cure those pre-existing provisions. But again, there may not be much teeth to this because we expect this to be rescinded almost immediately, and it's not something that a new general counsel will likely pursue in terms of prosecuting under the Act and prosecuting violations. Two more GC memos that we think are likely to be on the chopping block. GC memo 21-05, and this prioritizes the use of 10J injunctions to ensure timely enforcement of the Act, as well as during the pendency of NLRB proceedings. And the purpose of an injunction is to maintain the status quo and to prevent employers from undermining, activity protected under the Act, like union organizing or retaliating against employees taking adverse employment action during the course of litigation. And it really prioritizes certain violations. So, for example, if there is an unlawful discharge during union organizing, the board really looks at that as chilling the entire election process, and they take that very seriously. So in that instance, the GC would seek 10J relief and pursue that in court. Finally, GC memo 23-02, it outlines the GC's concerns about the impact of extensive electronic monitoring and basically using technology to surveil, for lack of a better term, employees, like cameras, GPS, key logging software, making sure employees are working when they say they're working. And the GC takes the position that this inhibits employees from exercising Section 7 rights because it creates a chilling atmosphere, an atmosphere of constant surveillance, so employees don't feel comfortable engaging in those protected concerted activities. Now, even if it takes some time for a Trump board to course correct many of the precedent-setting decisions that the Biden board issued, of which there are a lot, and Rufino is going to review them shortly with you, at the very least, a Trump-appointed GC will likely rescind many of these memos and decline to prosecute a lot of these violations and even dismiss pending charges that the GC was previously pursuing prior to the change in administration. So Rufino, with that, I will leave it up to you as to the board itself.
Yeah. So as Marianne stated, the board is comprised of 5 seats, typically 2 and 2, with the chair being of the party of the administration currently holding the White House. In our current situation, President Biden did renominate board chair McFerrin to a 3rd term. Her current term expires about a month from now, and those nominations are still pending in the Senate, as well as the nomination of Joseph Dittelberg, who is a management side attorney who's nominated to fill the open Republican seat. So what does this mean, right? So if the Senate does not rush to confirm either of these nominations or nominees, then when President-elect Trump takes office, the board will be down to only 2 Democratic members, which can have pretty significant implications for board law. So if there is a tie, then there's not going to be any sort of decision-making that is going to be effective from a precedent-setting standpoint. But if President-elect Trump immediately then fills the now open Democratic seat, will immediately have a 2-2. And if he does fill the 3rd Republican seat, then the majority of the board will flip pretty immediately soon after the Trump administration begins. So there are some implications here on whether the Senate takes action on these nominees or not. And we will just kind of have to wait that out to see how that all plays out and what that might mean for you all as employers and the issues that you're going to have to deal with once the new administration takes over. So the board during the Biden administration, as Marianne mentioned, has taken a very employee/labor-friendly perspective on a lot of its interpretations of what the NLRA requires of employers. The decision that we're highlighting here, CEMEX, actually relates to the unionization process. As Chair McFerrin was quoted as saying, she believes this is the most significant ruling from her 2 terms with the board. Why is this case important? So under the prior state of the law, if a union or a group of employees presented you as the employer with a claim that they had majority support for unionization within a specific bargaining unit, you would, as the employer, have the option to say, thanks, no thanks, we will not voluntarily recognize you. And that was it, right? Then it's on the employees or the union to file a petition for election. What CEMEX has done is sort of flip that on its head. Now, if the employees or union present you with a claim of majority support, as the employer, you now have 2 weeks to file a petition for election. So the burden is now shifted on all of you as employer representatives to make a strategic decision. Do we wait this out? Do we file the petition for election? Are they going to file a petition for election? If you miss that deadline and no petition is filed by the union, then there is an automatic duty to bargain that is going to arise from that demand for voluntary recognition. So if you think about it, what CEMEX has done is it's given the unions and employees a really powerful tool. They obviously have to have majority support, otherwise they're likely to lose that battle anyway. But the idea here is to streamline the process by which employees can have collective bargaining representation with or without an actual secret ballot election. If the petition is filed, whether by the employer or by the union representatives, the other aspect of this decision that is very important is that if there is an underlying unfair labor practice that was committed, the board may still not hold an election and instead might issue what's called a bargaining order. So what that means is, let's say, for example, the union files a petition, the election is pending, and in that process, a manager does something that qualifies as an unfair labor practice. So for example, they threaten employees with termination if the union is voted in. Pretty egregious violation. The board would say, you've committed an unfair labor practice, employer, and as a result, we're not even going to hold an election. You've polluted this voting environment to a degree that the only remedy that fixes it is requiring you to bargain with this collective bargaining representative. So all of that, has really provided unions a pretty significant power in this process. But more importantly, it has really shifted the burden to employers to, one, either filing a petition once the voluntary recognition demand is made, and two, it really requires you to walk on eggshells around your employees, around all of these issues, out of fear that if you do commit an unfair labor practice, you're going to be hit with a bargaining order that really deprives all of your employees of the ability to choose a representative through the process of a secret ballot election. Stericycle is another decision from this Biden-era board that has really provided a powerful tool to employees and the unions. What this decision did was scrutinize handbook rules, employer rules that are fairly straightforward, right? But what the law now does is it presumes as unlawful any workplace rule if it has a reasonable tendency to chill employees from exercising Section 7 rights or otherwise has a coercive meaning. So if you go through your employee handbooks and you look through all of your rules, for example, you might have a rule that says, employees should treat each other with respect, right? Nothing about that is, at least on its face, seems to dissuade employees from engaging in Section 7 rights. But if this board looks at that and says, when you say treat each other with respect, you're chilling employees' ability to engage in heated conversations that are not coercive, not threatening, but where they might have disagreements about what the workplace rules might or should be about their wages. So we're going to find that rule to be presumptively unlawful. In addition, because your employees are so economically dependent on you, you as the employer have to find the most narrowly tailored path to address these issues that you're trying to address. And if you deviate from that narrow path, then again, that rule is going to be deemed unlawful. Might not seem like a big deal to say, to have a federal agency say your rule is unlawful. But when you couple this decision, the Stericycle decision, with CEMEX and the bargaining order potential that an unfair labor practice will carry, it really has the effect of forcing you as the employer to be very careful about how you communicate with employees, not just during a campaign, but also through your employee handbooks and other workplace rules. So, again, this really was a change from the prior administration's priorities, which under the first Trump administration, handbook rules were subject to what was called the Boeing standard, which created 3 different types of categories for interpreting or reviewing the legality of your workplace rules. But the biggest issue was that the rules were, unless they were clearly unlawful on their face, the rules were going to be presumed to be lawful, and the employees or the unions had the burden of proving that for whatever reason the rule, either on its face or as written, created an unlawful condition, or as it was being implemented or applied was creating an unlawful condition for that set of employees. So again, it's not just that we're looking at your handbook rules here, it's the fact that they carry now the potential for an unfair labor practice finding that really is very powerful for the unions in the context of a union organizing drive. Another rule that or case that has really created a lot of confusion for employers and sort of a what now sort of framework is McLaren-McComb, which addressed severance agreements and essentially the decision said if you include confidentiality or non-disparagement clauses in a departing employee's severance agreement, that is a violation of that employee's Section 7 rights, because the employees should be free to badmouth you as the employer, badmouth individual supervisors or managers, and they should be able to discuss with other coworkers or with the public in general what you have offered them in terms of some of these benefits. So again, when this decision came out about 4 years ago or 3 years ago, a lot of clients were asking us, well, why would I pay somebody all of this money in severance if I can't actually keep them from, making disparaging comments about us as an employer? And it was a valid question. And so this is one of these cases where we do think there might be a change afoot here with the new administration taking over, because it is one that really impacts a very practical business reason for why employers are willing to offer severance at all, right? So in addition to getting a release of claims, you want to make sure that those departing employees don't soil your reputation as an employer online or on social media. And if you can't do that, according to this board, it's really a big detraction from any real motivation to provide severance at all. And then in the Amazon case, this is a big one as well that relates to the organizing process. Here, the board said that captive audience meetings, which are meetings where in the context of a petition for election, the union is campaigning, they are saying all sorts of bad things about you as an employer, they're talking about the benefits of having union representation. Typically, an employer could then have a meeting where it required attendance by all employees in the bargaining unit. And they would tell those employees, let's talk about why everything the union is telling you isn't quite as rosy as they say. According to the board, and this was also the subject of a general counsel memo, those types of meetings are unlawful. And they are unlawful, again, because of the coercive effect, according to the board, that they have in forcing employees to sit through and listen to your opinions on why unions are good or bad or something in between. Again, this is another area where we do expect some movement from the new administration because typically, under prior precedent, the board really balance these rights that employees have under the NLRA with the employer's right to free speech as well. The board took the position that this standard is consistent with the First Amendment. It has, obviously its pitfalls and some challenges have certainly arisen from this. But we do expect to see some change in this area under the new administration. In the interim, however, you do have to deal with this risk, which again, in the context of a union organizing drive, if you were to hold a captive audience meeting and the board found that it was unlawful, which it likely would under this case law, then you might be hit with a bargaining order where there is no election necessary, according to the board, and your employees will automatically be represented by that union that sought the representation to begin with. Okay, so are all meetings about unionization unlawful? So there is sort of a carve out here, which I will leave it to you to decide on your own whether you think it's really worth much. But the board has said that an employer can hold meetings that are lawful to talk about union issues as long as the employees are provided with reasonable advance notice. And that notice should talk about, it should include a notice of the subject of the meeting. So if you're going to talk about the union or the organizing drive, you should tell employees, hey, we're meeting at 2:00 on Friday afternoon to talk about the organizing effort that's currently underway. Your attendance is voluntary. If you choose not to attend, we're not going to keep track of who's there and who's not, but if you choose to forego this opportunity, you will not have any sort of adverse consequences. You will not be fired. You will not be retaliated against if you choose to not attend this meeting. Of course, when you give employees the option to sit through something like that or not, some of them will show, some of them may not. Typically, the ones who do not show are really the ones you want to be there because you want to sell them on the message to begin with. So the effectiveness of this carve out from the Amazon case is probably not, it's probably not going to do you a lot of favors if attendance is voluntary and employees just choose to not attend that kind of meeting. But again, we do expect this to be an area where there will be movement, whether it goes back to the prior standard for assessing the lawfulness of captive audience meetings or not is to be determined. But this is probably not going to be the last word in the next 4 years.
Okay, before jumping into a few of the rules that the Biden board has issued, I just want to, make clear our position that all those decisions that Rufino just went through, no immediate change in the state of the law. So, although we expect there to be movement, we have to be mindful that even, with Trump in office, before there is a Republican majority on the board, those decisions are the status quo. So we don't recommend, disregarding your handbook policies or maybe reverting to some pre-Stericycle policies. The state of the law remains the same for now. Where we do expect the change, like we stated, is with the new general counsel, there may be less of a zealous prosecution of some of those initiatives that she was seeking. So don't make any major changes. Just know that on the horizon, we expect the pendulum to swing into a maybe more employer-friendly realm.
Unless you want to be the test case to change the law, in which case you should definitely call us to make sure you have the best positioning possible there.
We'll be happy to litigate that. So now on to the what's called the quickie election rule. And the Biden board issued this rule last December. And basically, it amended the election procedure. So like Rufino went over, if a union files a petition for election, or if they, even if an employer has to file an RM petition because they received a request for recognition, it shortens the timetable for the election, and it really limits the ability to litigate any pre-election issues. And in a way, it really emphasizes speed over clarity of those legal issues. Now, why? Biden proclaimed himself to be the most pro-labor president in recent times. And a quick election process, in my opinion, and Rufino, let me know if you disagree, but I think, that really favors a union, right? A lot of times employers are unaware that a union is trying to organize their employees until right before they file that petition. So a lot of the times employers are already on the back foot and on the defensive when it comes to union organizing efforts. And by creating this rule that really shortens those timetables, a union is able to get to the ballot box quicker and really strike while the iron is hot. So this was a more favorable rule to, we think, unionization than an employer who is trying to take the time to educate their employees about what union organizing really means for them. So this is just a table that shows what the old rule was back in 2019 that the Trump board did pass versus the new rule. And you'll see here, when it comes to a pre-election hearing, the old rule had 14 business days from when we received service of the notice of hearing versus 8 calendar days. So obviously that truncates the amount of time before a pre-election hearing. So if you do want to try to litigate issues, you really have to hammer them out a lot quicker, get your witnesses together a lot quicker. It also limits the ability of a regional director to postpone a hearing or to postpone the filing of a statement of position, which is essentially the parties claiming their position as to the unit composition, what employees should be included, what employees should be excluded. Previously, the RD could postpone for an unlimited amount of time for good cause. So let's say the parties were trying to work out a stipulation of election and work through issues and agree upon issues, the RD would postpone it for however long the parties needed within reason. Now they really can't do that. Now it's 2 business days. If there's special circumstances, or more than 2 business days if it's extraordinary circumstances. In my experience, I really haven't had RDs be that amenable now to long extensions. Also, the purpose of the pre-election hearing. Previously, you would litigate individual eligibility. Let's say, certain positions the union wanted to include in a bargaining unit where we felt they should be excluded because maybe they did not share a community of interest with the bargaining unit. We would litigate that all in advance. And even strategically, we would choose to litigate because it could give us as the employer a bit more time that we needed to, again, educate our employees about the impact of unionization. Now, that individual eligibility cannot be litigated. So it really narrows the field of what we can present before a hearing officer. And then finally, the scheduling of the elections themselves. We had a 20-day waiting period before a decision and a direction of election. And now it's the earliest date practicable. So really the RDs try to schedule those elections as soon as possible. So again, what we expect is that a Trump board will now return to the 2019 rules. It gives more time for the parties to submit their papers, to have a formal hearing, to submit briefs, and it returns to pre-election clarity, hammering out all the issues first over speed of just getting the election on the books. Finally, there was also the Fair Choice Employee Voice final rule. It reinstated pre-2020 what's called the blocking charge policy. So let's say during the course of an election, there's an alleged unfair labor practice that a regional director thinks is sufficiently serious as to interfere with an employee's free choice. If that occurs, basically the RD will delay an election, and this delay could really stretch for months or years until those ULP allegations are resolved. A lot of us know that the board is short-staffed. There's a huge backlog of cases. So with this blocking charge policy, elections have the potential to really be delayed for a significant period of time. There's also the voluntary recognition bar as part of this rule. And basically, if a union comes to an employer, seeks voluntary recognition, and if an employer does agree to voluntarily recognize, previously there used to be a 45-day window where employees could say, you know what, I don't like that my employer voluntarily recognized the union. I, as the employee, want to petition for a secret ballot election. I think me and my coworkers, we should put this for a vote. Now, this bar abolishes that 45-day window. So there's an immediate bar to holding any employee vote concerning unionization, and it's for a, quote, reasonable period of time. And the board has described that being at least 6 months to 1 year from a first bargaining session. Now, 6 months to a year, that's, I think, a large amount of time. And really, I think it says fair choice employee voice, but in a way, I look at this as almost disenfranchising employee voters. So we think, with the new administration, the blocking charge policy will go away. There'll be a return to that 45-day window after voluntary recognition. That's where we kind of see this going. And with that, I believe that is all for our NLRB update in this post-election world. So now we're going to move on to another, major federal agency, especially in our world of labor and employment, the Equal Employment Opportunity Commission. So briefly, just an overview. I'm sure everyone knows this, but the EEOC, what is it? It enforces federal laws that prohibit discrimination in the workplace. So we have Title VII, which prohibits discrimination on the basis of, race, color, national origin, sex, religion, the Pregnancy Discrimination Act, Pregnant Workers Fairness Act, Equal Pay Act, the American with Disabilities Act, the Age Discrimination in Employment Act, and the Genetic Information Non-Discrimination Act. What do we potentially expect from a Trump administration in regard to the EEOC? Probably less focus on enforcement, less focus on litigation, maybe more so on conciliation, on mediation programs, on educating employers. Obviously, Republican administrations typically are more friendly to businesses and employers. So maybe more of an emphasis on proactive education and guidance versus punitive action. So the makeup of the EEOC, we have the commission itself. It's composed of 5 members, again, like the board, appointed by the president, the consent of the Senate, and they serve 5-year terms. And the president designates 1 member to serve as the chair. So here we have currently 3 Democratic members, the chair, the vice chair, and then Kaplana Kotagal. And then we have 1 Republican member whose term expires in 2025, Andrea Lucas. And then we have a 5th seat that is currently vacant. So Lucas was appointed by Trump during his previous term. We expect her to be the de facto pick as the chair because she is the only Republican appointee that is currently on the agency. And as chair, she would have the ability to set the EEOC's agenda, determine what items are presented to the commission for full approval. But she may be limited in her ability to really push policies forward, at least initially, because she will be outnumbered by Democrats 3-1. And then this will continue for at least some period of time, because even when the vacant seat is a Republican appointee, the Democrats will still have a majority until the vice chair's term expires in 2026. The general counsel, also a Democrat, Carla Gilbride. We do expect Trump to seek a replacement ASAP, obviously. But unlike the board, the EEOC's general counsel, they do litigate on behalf of the agency, but I don't think there is much of a policy pusher as the NLRB general counsel is. So, in the absence of a confirmed successor, we think that the position will likely be filled by just, a member of the career staff in the GC's office, obviously a Republican, until Trump appoints who he wants to appoint. Okay, Rufino, can you discuss the harassment guidance updates?
Yeah, so a few months back in April, the EEOC provided updates to its guidance on harassment in the workplace. And the guidance had not been updated in 25 years. So a lot of it is clarifications that relate to recent rulings by the Supreme Court, in particular, a ruling that extended protections under Title VII to LGBTQ employees. The new guidance includes 70 hypothetical examples of potential unlawful harassment, all of which really is, a lot of those examples reflect the last 25 years of legal and social changes since that last update in 1999. And for those of you who care to know, I was in high school in 1999, so it's been a while since the commission actually decided to update some of these examples. If you've ever looked at the guidance that the EEOC published, even those 1999 examples provided really good information for employers in terms of potential examples. A lot of it relates to just scenarios that might come up in the workplace, and the new hypothetical examples are also very useful. So if you ever find yourself in a scenario where you think, what does the EEOC expect me to do? Look up the guidance, see if there's an example that comes close. They're usually very general, but they do address a lot of the potential situations that you as employers might be dealing with, and they will provide you some pretty useful guidance. So look at it, definitely turn to it whenever you do have a sticky situation come up in your own workplace, and try to rely on it as best you can. Obviously, if there are detailed questions, you can reach out to your legal counsel for additional guidance on those issues. So what are some of the updates in particular? So intra-class harassment. There's a section in the update that addresses this issue, which is harassment that occurs within the same protected group. The most common example that typically comes up is within the protected age group. So, as many of you probably know, under the Age Discrimination in Employment Act, if you are 40 or older, you are protected against age discrimination. But what happens when a 45-year-old harasses a 60-year-old about their age? That is also prohibited activity. The fact that both of those employees are in the protected group doesn't make that type of harassment okay. So there are examples and guidance provided for those types of scenarios as well. Intersectional harassment is, for example, if a woman over the age of 40 is being harassed for being a woman, being over 40, and based on stereotypes of being an older woman, for example. So in this case, both Title VII, which covers the sex or gender discrimination, and the ADEA, which covers the age discrimination, could apply, right? So it's essentially harassment that crosses multiple different protected statuses, but not just necessarily under Title VII, but in addition, other laws that might be in play. And then the guidance also provides some examples and guidance related to colorism, which is color-based harassment due to the actual pigmentation or complexion of somebody's skin. A lot of, there is case law on this particular issue where harassment occurs even within members of the same race. But there, you know, if you were to Google light-skinned African-American, for example, or dark-skinned African-American, you would find examples of case law that have addressed harassment because of the color of somebody's skin tone. It can happen across races, but it can also happen within the intra-class of you know, the same race, where you have people harassing each other just because of the color of their skin. Then with respect to pregnancy, the new guidance also provides some pregnancy-specific examples. This type of harassment is based on a woman's reproductive decisions. It may be actionable by the employee and may be demonstrated by employees making negative comments about another employee's choices, whether it's to use contraception or to seek abortion care or other sort of prenatal care. Negative comments concerning a pregnant employee who is allowed to telework, and sort of harassing the employee or making comments, even if it's to a different employee, about those sorts of situations can constitute harassment according to the latest guidance. And then harassment based on pregnancy-related accommodations may also be actionable, right? So again, an employee working remotely or an employee who, because of the pregnancy, now has a mobility impairment that requires them to get some sort of accommodation, harassment related to those issues will be problematic according to the EEOC. And as an employer, you have a duty to address those issues as they come up. Sexual orientation and gender identity guidance incorporates, again, the Supreme Court's decision in Bostock, which said that Title VII prohibits discrimination based on sexual orientation and gender identity. So some of this harassment can include outing, misgendering, dead naming. So outing, for example, is disclosing an individual's sexual orientation or gender identity without that person's permission. Misgendering, of course, is the intentional or repeated use of a name or a pronoun inconsistent with that individual's gender identity. Again, this is an area where we are likely to see some change or maybe some walking back, even if it's not necessarily through changes in the harassment guidance document itself. Those prosecution decisions and whether to consider these sorts of issues to constitute unlawful harassment or discrimination are going to be left to the commission to sort of set, guidance to all the different regional offices as the new administration takes shape as well. So again, just kind of keep these things on your radar, as there are likely to be some movements. But as Marianne said earlier, in the interim, this is the state of the law. These are the enforcement priorities that the EEOC currently has. And it will take some time for things to change. So until those things formally do change, employers should continue to abide by this latest guidance to avoid any unnecessary legal claims. So some of the new chairs or suspected chairs policy priorities Just speaking broadly, we're looking at some movement and some changes in the DEI space. So the narrative around diversity, equity, and inclusion has been changing quite a bit. Many large organizations have walked back prior stances on DEI programs. They've either changed them in light of recent Supreme Court decisions addressing affirmative action. The potential new chair has expressed some critical views regarding some of these DEI initiatives as well. So she has emphasized that Title VII prohibits all forms of discrimination, not just marginalized or underrepresented groups. And that is a very important issue to keep in mind. I've had discussions with people who under Title VII, and that is a mistake, the way that it is blind in terms of which groups are protected. So you can have discrimination against Caucasian employees, against male employees. So those things can be actionable if they satisfy all of the other elements of a discrimination claim. So just something to keep in mind there as well. In the religious liberty space, we do believe that Ms. Lucas will be an advocate for protecting religious freedom. And so how that takes shape is yet to be seen, but we do expect to see some movement and some changes around that area as well. So I will now take us into a brief discussion of some of the potential issues that are coming up within the Occupational Safety and Health Administration, which of course is a department or a part of the DOL. It's the agency that ensures safe and health working conditions for U.S. workers. During the first Trump administration, there was a significant reduction in the number of inspectors and the number of inspections that were conducted by OSHA. They were historically low. If you think about this number on the screen, 752 OSHA inspectors during fiscal year 2019. Those 752 people were the people charged by the agency with going out into the field, into your workplaces, to conduct inspections, whether they were driven by complaints, programmed inspections, or otherwise. That is just a very minuscule number of people charged with that level of a task. Under the Biden administration, there was an increase in the number of inspectors, but even where we are today, that agency is still currently understaffed compared to what it typically would run, pre-2016. So we don't know necessarily that President-elect Trump is going to have this as a major priority for his new administration, but we do anticipate that the number of inspectors may remain static or decrease. We don't anticipate a significant increase in enforcement activities by OSHA, at least not in the early days of the administration. I'll turn it back over to Marianne here.
Thanks, Rufino, and apologies if you noticed my disappearance and reappearance. Some technical difficulties on my end, including the fact that my slides screen is blank, but I was a Girl Scout and I did print out my slides in advance. So if you see me looking down, that is why. Anywho, but that's showbiz, right? So the walk around rule. This is another rule passed during the Biden administration. And basically, so this regulation actually has really been sought by organized labor and opposed by the business community for reasons we'll touch on in a second. But under the OSHA Act, both employers and employees have the right to have a representative accompany an OSHA compliance officer during a physical inspection of the workplace. So some of these may be pre-scheduled. A lot of the times, I'm sure some of you folks out there have experienced unannounced physical inspections where an OSHA compliance officer just shows up on site to conduct that inspection. Under the prior rule, the representative of an employee who chose to be present had to be an employee of the employer. However, this new rule now clarifies that, like employers who can have a non-employee representative with them, employees also have the right to designate a non-employee third representative to be with them on site during the inspection process. So, what does that mean? Interestingly, this third-party representative is not limited to people with formal training, with an industrial hygiene background or a safety engineer, as long as it could be demonstrated that they're reasonably necessary to conduct an effective and thorough physical inspection of the workplace because of their knowledge, skill, or expertise. And I know what we're all thinking, well, who can an employee invite to come along with this inspection? The practical concern is that this new rule now could open the doors of your business to union organizers, community activists who activate for workers' rights and worker safety, industry competitors even, or anyone who claims to have a vested interest in employee workplace safety can join the walk around to the site. Obviously, as an employer, as a business owner, as an operator, you care about who comes into your facilities, especially if there's potentially confidential information, if there's trade secrets, if you're, let's say, a manufacturer and you have a proprietary way to do something. You don't want just anyone coming around and walking around your shop. So now we're in a situation where this new rule, offers the opportunity for a variety of people to come in, as long as the compliance officer could reasonably deem that they somehow aid the process of the walk around. Now, the rule is currently being subject to challenge. I think it's winding its way through a district court in Texas. But if it's not struck down with the courts, we imagine that a second Trump administration will very likely repeal it, just because it's really not employer friendly. And it's something that businesses really opposed when it was being floated about. So I will now kick it over to Rufino to talk about the heat safety rule.
Yeah, so this is a big deal here in states like Texas, where it does get hot. But overall, this proposed heat safety rule would require employers to really monitor the conditions in which their employees are working. This is just a proposed rule, it's not final. But if it were to be implemented, and we don't expect this to really be a focus for the Trump administration, in states like Texas, for example, there was legislation that was passed to actually prohibit local city and county governments from implementing rules that required these types of breaks. But it would require you to monitor certain, one, the temperature, of course, the working conditions, and then there were certain triggers that will require different levels of care from your side of the equation, depending on how hot it might be outside. So the two main triggers are, essentially 80% Fahrenheit, 80 degrees Fahrenheit and 90 degrees Fahrenheit. So at each of those triggers, when you hit the initial trigger of 80 degrees, you would be required to implement things like, providing cool drinking water, break areas that are shaded or in an air-conditioned space. You would also be required to encourage employees to take those paid rest breaks as needed and to effectively communicate those new working conditions for those employees. At the 90-degree high heat trigger, you would then be required to provide at least 15-minute paid rest breaks every 2 hours. Again, there's a notification component that would apply for telling employees about the importance of staying hydrated and their right to take these breaks. You would also be required to implement a pre-approved method for observing employees for signs and symptoms of heat-related illnesses, which would of course require you to train your management and supervisors on how to identify those potential types of injuries and illnesses. With regard to these heat and safety rules, the pre-approved protocol to help new and returning employees acclimatize to heat conditions, right? So what that means is going to change on each work site, on each type of work that the employees are doing, but it's going to require you to have these different types of plans of action for all of the different employees that you might have. So obviously in the construction industry, that's going to be different than in a manufacturing setting where you might still hit those heat triggers. So you'll just need to be very nimble about, you would need to be very nimble about how you respond to those issues. Now I will say, and I know that we've hit our time here, but I'll say that with respect to these types of issues, I have never run across a client who has said, I don't care how hot it is outside, I'm not going to give my employees any breaks. So a lot of this is really intended to address those sort of bad actors that are out there who do take that position. Overall, most employers, and certainly all of the clients I've ever advised, have already taken a lot of these steps to protect their employees. But obviously, if this were to become a formal rule, it would become required of you to do these and take all of these different steps to ensure that your employees don't suffer from heat stroke or other types of illnesses.
Okay, and we'll briefly go over the next two slides, just some additional insights. Obviously, immigration was a big part of President Trump's platform that he was running on, and he raised the issues often. So just some a quick tip when it comes to immigration and how a Trump administration would affect immigration. Obviously, a lot remains to be seen. There's a lot of unknowns, but probably one of the easiest things you could do is an internal I-9 audit. Make sure your I-9 paperwork, which is required to verify the eligibility of every new employee to work in the U.S., make sure all your documents are in order. It's something that's, can be really simple for you to get the ducks in the row. During the Trump administration, there was an extreme increase in those audits. With COVID-19, that tapered off a bit, but obviously, that could be indicative of future action. And especially for industries that could have a high share of immigrant labor, potentially be targeted for those types of audits. Also, just keep in mind, again, we don't know what's going to happen, but possible workplace disruptions that we could face if travel bans are implemented, increased scrutiny of immigration filings. There was the rescission of deference where prior filings and approvals were given deference. That's no longer. And to the extent, visa approvals, all those processes take longer. That obviously takes more time, more money as well. When it comes to immigration, just don't forget your anti-discrimination obligations in the workplace, Title VII, and making sure, that there's no hostilities in the workplace and to create an equal opportunity environment for your place of work. And then Rufino, if you could just bring us on home here.
Yeah. Absolutely. So many of you are, I'm sure, aware that the Biden administration issued a final rule that would have raised the salary, or that did raise the salary threshold for the white collar exemption. So your administrative exemption, professional employees would have needed to make $59,000 a year to classify or to qualify for that, the exemptions and to satisfy the salary basis test. It would have potentially created additional overtime for 4 million workers. That's the estimate that's been floated around. And it would have gone into effect at the beginning of 2025. So just a few weeks before the new President-elect Trump administration would begin. The litigation was pending, and it still is pending. But on Friday, the Texas federal court issued a nationwide injunction halting the rule from taking effect. So, you know, this is an area that is going to continue to create some issues. The biggest takeaway from this ruling isn't necessarily that you don't have to worry about anything, but as is always the case with wage and hour issues, it is of critical importance that you as employers self-audit, go through your job descriptions, determine whether your exempt employees are truly exempt. That was the entire purpose of this rule, was to force employers to rethink whether they're classifying employees properly. That issue, even though it may not necessarily be in this rule, if it ever is implemented or not, remember that every one of your employees can act as their own representative and advocate on these issues, and they are always free to go to the DOL, which can then trigger an investigation into your classification practices. So to the extent that you have employees who are borderline on that, are they really administrative or managerial employees, go through that process internally or with the assistance of counsel. If you want to at least cloak that investigation or audit in some form of privilege, you can try to do that. The last thing I'll say is no taxes on OT or tips. That was a promise of the Trump campaign. We'll see where that actually goes. If that happens to pan out, it will probably create some administrative burdens on your end in terms of tracking taxes and tips and whatnot. For those of you who are in the service industry, that will be of critical importance for you as well. So just stay tuned. Thank you all very much.
Yes, thank you for joining us today, and we hope the information was helpful to you and your organization. Please feel free to reach out to either of us if you have any questions. And as a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. This concludes our webinar, and thank you very much.